First, could you please look at the camera and introduce yourself with your name, your title, your pronouns, and what song best describes you, but don't explain why?
Wow. I am Moná Scott, Judge of Cleveland Municipal Court Housing Division, also known as Cleveland Housing Court. Um, what song best describes me would probably be I'm Every Woman.
And pronouns.
My pronouns are she and her.
Could you explain what housing court is to an average Clevelander who may not be familiar with it?
Absolutely, because we do that a lot when we go out into the community because people don't understand the roles of the court and the judicial branch. So I always tell people it's the executive branch, judicial branch, and the legislative branch. Do a little civic studies or lesson. And the executive branch is the mayor and all of his cabinets. The judicial are the courts and the judges that preside in those courts, and the legislative is city council. This is just on a local level, and this is a municipal race. So I am a member of one of the 13 judges on Cleveland Municipal Court. There are 13 judges, but there are only one judge for Cleveland Housing Court. And although it's a separate division with separate jurisdiction, I preside over that court. Let me also say that housing court has a civil docket and a criminal docket. Everybody believes that the only thing housing court does is the evictions and the move outs and property damage. But we have jurisdiction over code enforcement throughout the city of Cleveland. So Cleveland codified ordinances have codes that governs building, housing, health, zoning, and fire. So at any point, the code enforcement prosecutors, which are a very specific group of prosecutors, can bring a case against any LLC, any property owner in the city of Cleveland and Bracknell, and it would come before my bench.
We like to ask candidates why they're running, but for you it's a little different because you're already on the bench. Could you give a short state of the court for the public, recent events, successes, and areas for improvement?
So I ran in 2019 and won, and I was probably the only new judge in Cuyahoga County. If we know 2020 was the time of the pandemic, 2.5 months on the bench, the pandemic breaks out. My role became a lot clearer to me and a lot more important because housing is vital. I believe it's a constitutional right, but we live in a capitalistic society, so that's not afforded to everyone. So my concern was that a pandemic is hitting. There was a 30-day shutdown, so people couldn't go to work, people couldn't make money, and it was a concern because it was a shelter in place until they get a better understanding of it. And we were also ordered to stay all of our cases. My boss is the Ohio Supreme Court, and so the courts never can close down, regardless of a nationwide pandemic. But we were tasked with trying to create a space and convert a court that was always ran in person into a virtual court. Me and my team immediately went into place and we created a virtual policy. We selected Zoom being the link. We bought the equipment. The Ohio Supreme Court gave all courts a $60,000 grant. We immediately purchased laptops, Zoom links, VPNs, and things like that that allow us to begin setting up a process to move all the cases that have stayed. But then how was that going to look for people that wanted to proceed as though the pandemic wasn't here? I feel like sitting on this bench is very important. It is important because the volume is very high. During the pandemic, the volume has been below what the intake for evictions were in 2019. And that's important because if you recall, back in 2019, a lot of single mothers were being evicted with children, and there was an overcrowding in the homeless shelters. Uh, the city council passed right to counsel, and so that took effect July of 2020. Then also the lead safe certification was passed pre-pandemic, that took effect in 2021. So all of these things me as the new judge had to create policies and procedures on how this would look as we navigate forward. It has worked to our advantage because one of my platform was to make housing court more accessible to the everyday person, knowing that as a former fair housing administrator, there was a digital divide, meaning a lot of people didn't have access to digital equipment, Wi-Fi, or any of those things. And when I thought about having virtual court, I knew that there was a serious lapse in the city of Cleveland where a large portion of citizens didn't have access or wasn't going to have access. So we created the first Zoom kiosk, which was in our conference room on the third floor. So people would come in, we would place them in there, we would sanitize it every time each person came out. We provided masks if people didn't have masks. And try to do separations when people came down to keep everybody safe and protected from COVID. But not only that, the Justice Center is just an icky building. It doesn't have
Yes, it
fresh
is.
air. So any outbreak of the flu or anything can happen. So, I was really concerned about our seniors and also children, being affected by COVID, some of our more vulnerable ones. As the pandemic progressed and as we started gaining knowledge and these processes started working, I instantly thought to put Zoom kiosks into the neighborhood. So we ended up rolling out four in four Cleveland public libraries. We had to wait for all of these facilities to open back. So we have two on the west side, two on the east side, and individuals who have any virtual hearings, whether it's criminal on the criminal cases or the civil cases, they can go into the kiosk and not have to come downtown. We do still have our third floor kiosk. And for criminal cases, a lot of times we have a kiosk set up, a portable kiosk set up in our jury room. For those attorneys who are hopping from courtroom to courtroom, can have a place to hop on to help their clients that's before housing court, and that individuals that are downtown are taking care of other businesses because some people love to just come downtown. And so we are prepared to take on those individuals also.
Was there a process to your decision to run again? Why specifically are you running again?
I'm running again because I'm almost completed my first term, and I think there's still work to do. Processes and procedures as we come more and more out of the pandemic, and there's a move to bring everything back in person. I feel like there's things that are so necessary because so many people, so many Cleveland residents, Bratton residents don't have any clue about housing court. We know that a lot of people that come before housing court has never been before a court ever. So again, that's another reason why I like the virtual hearings because it allows people to come from the comfort of their living rooms. And so they won't feel intimidated coming through the Justice Center security, the court security, and being present in an intimidating space. So I want people to feel a little bit more secure at home. And I gotta say, the people that come in virtual course are very mindful and respectful. I don't have bad stories like some of my colleagues about how people appear on virtual court. My only thing is that you must be on time. Your equipment must be working. If it's not working, you must go to one of our branches at the Cleveland Public Library, and you must be presentable as though you're in court. So you can't be laying down or relaxing or eating or smoking or anything like that while on the virtual hearings. I feel like there's still things to do, policies to shape. The law is fluid, as you'll know, and when those laws changes, it requires the court to be prepared to process things as it change. We do have the new right to counsel that was passed by the city of Cleveland that it overhauled and changed a lot of the laws that come before my bench. And then there are some ORC changes going on in the background. And I think I have a bird's eye view of how that'll look. Will it be successful? Will it not be successful? Working from the bench because it involves so many different actors. I have a perception of how that'll look moving forward. So some things I want to roll out to the community that I'm still rolling out to the community And I just want to connect people to resources and learn about housing court and how we are a court, but we're there to connect people with resources and be more proactive than reactive. Because if we're being reactive, that's because you have a case before my bench. So
You mentioned there are changes both in city ordinances and the Ohio Revised Code.
mhm.
Could you explain a little bit uh, what the difference is in effect on
Okay.
you, maybe to a Clevelander who knows Ohio has a constitution and the city
Mhm.
passes something?
Right. So the Cleveland Codified Ordinance limits its jurisdiction just to the city of Cleveland. When they passed or they overhauled the Cleveland Codified Ordinances that was just building the housing, health, and zoning, they dubbed it residents first. And that changed the way that they file the complaint to what is considered a misdemeanor versus a minor misdemeanor. How the city goes about service to they enacted civil tickets that have nothing to do with the court. So I want people to know that is a city of Cleveland thing that is put out by the Department of Building and Housing and their inspectors, and they're responsible for that. We just know that if you have a case and we see a civil ticket, we really don't have information because it's new and it's not that much public. It's not accessible as well as it should be to the public. Um, and so that's the difference between the city's ordinances and laws versus the Ohio Revised Code, which is governed by the city, governed by the state. And one of the things that a lot of people didn't know about, because I get questions a lot about the out of control rent prices going up. In 2021, and it went into effect in 2022, during the pandemic, Governor DeWine signed Ohio Revised Code, I believe it's 5321.19, that prohibits any municipality from creating any rent control or rent stabilization policies. And so, where we got right to counsel, just like the city of New York and DC and San Francisco and Los Angeles, one of the things I was hoping that would happen would be a rent control or rent stabilization policy created by the city of Cleveland. Um, but due to the lobbyists of the apartment association that heavily lobbied, it was enacted in 2021 that no municipality can create a rent stabilization or rent control policy governing the properties in their jurisdiction. So those are the two differences that we have. And there are some other things pending, from dealing with squatters to dealing with evictions and offering sealing of those evictions and such. We do have a sealing policy in place so that if you have an eviction on your record, you have a right to request the court to seal it if you've met all of the qualifications of that seal. And because our mediation that takes place on our civil docket has tripled, we now have a lot more individuals sealing their eviction records and also including that in their agreed judgment entry when they decide to mediate the case and remove it from first cause hearings or eviction hearings. Oh, we got an RTA.
Along the lines of rent control, your reputation precedes you of being a strong and committed fighter for the rights of tenants, even so far as getting flack for your comments, which correctly called out the insidious ways in which networks of out-of-state landlords can work together to screw Cleveland renters. As you said, the housing market continues to decline in quality. Rent is exploding, and the institutions are increasingly going the conservative way. In your position, if elected, how will you support working class Clevelanders against absent or uncaring landlords?
So if re-elected.
If re-elected, thank you.
That's okay. So I'm very mindful of my role as a judge, and it's very limited, but it at the same time doesn't prevent me from offering my opinions that really don't come before my bench. How have we dealt with out-of-state landlords? So I took that as not fact, right? Because the myth is that we have a tremendous amount of absentee landlords that don't care about the property. And I've been on the bench for 5 and almost 6 years, coming on 6 years. That's not what I've really seen. The problem that I saw was that how service was going out to put those landlords on notice. And those were things that had to be reshaped by the city of Cleveland, the code enforcement prosecutors, and the inspectors. They were sending these notices, these violation notices out to the tax mailing address. Well, if it's an LLC, you're required to send it to a statutory agent, and you get the statutory agent through the Ohio Secretary of State. And if they are not registered with the Ohio Secretary of State's on the books and Cleveland Codified Ordinance, that's an offense that the code enforcement prosecutors could charge. When I initially took the bench and we were going through these and I was figuring out, I noticed that those charges were not prevalent, and that they weren't, some of these LLCs weren't registered with the Secretary of State. So, there was a push from the bench to encourage the prosecutors to use their codes that they have to combat this, but make sure that when the inspectors send out these violation notices, they're not just sending them out to the text mailing address, and that when they come before for arraignment, that when they file their complaints and the complaint comes with a summons, that the prosecutors also list the statutory agent, because statutory agents' only goal is to receive certified mail, any court filings, and pass it along to their client, which is usually a LLC. So once we figured out that process, the numbers on our corporate docket, which is a docket that was created, I believe, by Judge Pianka, that when LLCs did not make their arraignments and service was perfected, they're placed on that, with which they incur a 1,000 per diem sanction for every day they don't appear, that they don't answer to the court, and eventually that sanctions will cause a lien to be placed on their property, and they won't be able to transfer it or anything like that. So during the pandemic, and when the interest rate percentage were 2-3%, we had a heavy uptick of LLCs coming before the court asking to mitigate those fines and sanctions, and then lifting them and taking care of their criminal cases, and then so that they can be allowed to sell the property that they want to get rid of to another LLC. So that lowered our amount down, but I also, on the criminal docket, require the defendant representative of the LLC, whether it's the sole proprietor, the principal agent, they have so many different names that they call themselves. The owner of the LLC must be present to do the change of pleas. They must also be present for the sentencing, and they must also come back if they're placed on community control, which is probation, so that they are aware of what's going on with their property, and that it is not to the sole responsibility of the property manager, because we also learned that property managers don't necessarily tell the property owners that they are outstanding violations, because we also found out some property owners sent money to correct the violations and make the repairs, and the property manager never did it. So it's a lot of moving parts. What I've known is that the out-of-state, out-of-country landlords are interested in what's going on with their property, and it's a learning curve for them, because we've taught them to be better organized. If they have a lot of properties, we have people that come in and flip property back and forth, and there's open violation notices. So I either do two things. I either do an oral do not give, sell, or transfer properties without the court permission, or I do a written lis pendens, which is you're prohibited from gifting, selling, transferring the property without the court's permission, and it shows up on the title, because some landlords, and they're the local ones actually, are a little crafty. In that they try to move the properties because they don't want to be under the court's control and jurisdiction, but it's not the individual LLC as much as it is the property. So we now have a lot of them transferring the LLC into a newly created LLC, so they can, they say for finance, but they're under the misbelief that once they transfer, I don't have jurisdiction over that new LLC, but I still have, you know, um, jurisdiction over the property, especially when I place on record that you're the owner of the new LLC, the defendant representative, and that's still under, we still expect for you to close out the violation. We still expect for you to get your rental registration, your lead safe certification, pay your taxes. I have, since I've been on the bench, I've collected millions of dollars. We don't calculate, but we make sure that they set up payment plans. And in actuality, a lot of the overhauling of the new residents first was based on how I was running the court and the docket. So they won't give me credit for that, but I require, these are things that I always require. You get your rent registration, or you get an affidavit saying the property is vacant and you're not receiving anything of it. If it's vacant, you have to properly board it up. If it's occupied, rental registration, lead safe certification. You also have to pay your property taxes. You also have to close out any violation notices, any permits. And I have to be able to search and see that those violation notices are closed out. Because unbeknownst to a lot of them, we closed that out in 2019. We made the repairs in 2019, but it's still open. And so I make sure through my housing court specialists, also my community control officers / probation officers, are making sure that it's closed out on record, that the inspectors have closed them all out. Therefore, and then they do a motion to terminate. And so we put in the motion that you've done everything the court has ordered you to do, include closing out. We list the violations, the permits, just so they can have a record. And that's another thing that I did, is I improved the record keeping of our hearings. We take a little bit more time on our journal entries. It's not checking off boxes, but it's actually issuing judgment entries and orders.
To follow up on what you just said, quickly, I would just like to say, you mentioned that you see the main two issues not necessarily being uncaring out-of-state landlords, but that those landlords are not served correctly, and so they are unable to address the issues that tenants have.
Right.
Okay. Next up, I'd like to talk about the corporate docket, which you also brought up. And you spoke about how enforcement of ordinances can be spotty at times with the prosecutors. And it's been sort of one of your directives to emphasize or encourage these prosecutors to have these violations pressed. Are there, so I guess it's a two-part question. The first part is, what are the penalties for repeat offenders, for people, slumlords? Cleveland has plenty. And then second of all, how often do these, per day charges that can build up really quickly, how often do those actually get paid in full?
So here's my thing. I always take an approach of talking about the sanctions that can build up. There's been anywhere from 80,000 to 190,000 to 1.5 million, depending on when the court pulls it, and just stop collecting and just put the case as a whole hard capias. When they come before the court, they do a motion to mitigate. And so my intention is never to cause financial hardship on any property owner. I believe that you may not know what you should do. And so I don't want to start off any interaction with the court on the criminal docket from a space of fear, right? And shock. And so I've had to calm some property owners down, because and I'm amazed at how they don't take care of their properties, or they don't know anything about their properties. So it's been a wholehearted educational component from the court. The court we started a true landlord training, and a part of community control or probation is that a lot of times I may order them to come and attend. If they're out of town or out of country, we've had some come in because I think they need to put faces to names. So we have Department of Building and Housing inspectors present, health inspectors present, and we really walk them through the process of how do you do an eviction to how do you handle a case if it lands on the criminal docket. And we've gotten positive feedback. I think we've trained over 400 landlords and property managers and attorneys that have attended the landlord training over the years since I've been on the bench that we could do it. In the beginning, we had virtual trainings, virtual resource clinics, because we couldn't find a place to meet in person, and I didn't think it was safe for us to meet in person. So people were allowed to log in on our Zoom link, but then also appear on our Facebook Live that they would ask questions, and those questions would get to me, and I'll try to answer them to the best of my ability. But the ones early on were just to explain how to go about getting rental assistance, to how to navigate the new virtual hearings and the policies and procedures that we put out in place. The number one thing that's going to be with everybody, including nonprofit organizations, anywhere, is putting people on notice that this is here. That's always been a challenge since I was a fair housing administrator. I was also the tax foreclosure prosecutor that introduced and got together the Treasurer Department coming out into the community. So they have a whole program going on now. But if you go back in 2018, 2019, I introduced that to the prosecutor's office. And Sweeney, who works over, the treasurer's office with the county tax foreclosure prosecutors, we put together a program because, again, my concern was a lot of senior homeowners didn't know about homestead credit. They didn't know about owner occupancy credit. That's 2.5% that you get off of your property taxes if you are the owner and you occupy the house. And they didn't know about how to go about doing a payment plan, and how paying your property taxes when it's in the throes of foreclosure should be your top priority. We talked to a lot of homeowners like that. I also learned that a lot of properties got lost from tax foreclosures because the kids were infighting over the deceased parents' property. So I've been passionate about introducing people to the death on deed transfer, but also talking to parents to say, do not leave it to all your kids. Leave it to your one best kid that's responsible, because there will be infighting. A lot of parents believe their kids get along perfectly well. They don't. I've seen it over and over again. Doesn't matter the race, doesn't matter the economic status. I've seen it. So it's always going to be one kid that is fighting with the siblings because they think they're trying to tell them what to do or they're trying to control everything. And so I'm kind of mindful of that, but also teaching seniors that if the spouse dies and usually the wife hasn't paid bills, the taxes fall behind, it's kind of reaching out to the kids to let them know. That's why I feel like connectivity and networking is everything, because a lot of times it would come across and someone knew the person and was like, their spouse died and their kids are doing well. I don't think the kids know. And so they have a right to get the house out of foreclosure, but a lot of people shut down and don't attend those hearings. So education is really important. We've gotten landlords, only one house is before the court, but I have jurisdiction over that ABC 123 landlord, and we bring all of their properties in. So we do a health check on all of their properties, and we create an Excel spreadsheet. We've helped these landlords get organized with their properties. They honestly can't tell you, I don't know, I think I own 20 properties. You actually own 30. And it's just teaching them how to create a notebook, or if you're not digital, which a lot of them aren't, create a notebook and track your properties from what the court has ordered you to do to having all the violation notices, all the permits, how to ask for permits when you hire contractors. It's a lot of training that goes on, how to communicate best with your tenants. so that they don't file any complaints against you, motion to compel repairs, and then also teaching the landlords about temporary restraining orders to get into their properties to get those last safe certificates or to make those needed repairs versus the temporary restraining orders of the tenants to get them to turn back on the water, to remove the change locks because you can't do a constructive eviction, and just teaching everybody about that, telling tenants to pay their rent if they're living in uninhabitable, living environment, do a rent escrow, and then do a motion to compare repairs. That way, they don't have a reason to evict you because a lot of the evictions come down to, well, I have a leaking roof and my water hasn't really ran correctly since I moved in. You can't withhold your rent because every property owner has a right to get their property back. But through the corporate docket to bring them in to actually getting those summons and complaints out, and holding them accountable. Uh, a lot of them get on there and they do exactly what they need to do and they get off pretty fast. Some get off pretty fast before we even get to sentencing. And so I just would give a fine. But it's every failure to comply with the notice of a violation is an ongoing offense. And every day that an LLC doesn't comply and it's an ongoing offense, each count is a maximum fine of $5,000 and up to 5 years of community control. For individuals, every day they don't comply to correct that violation and the violation notice is an ongoing offense. So it's $1,000 fine, 180 days in jail, no more than 18 months, and up to 5 years of community control. So you'll hear a lot of people say, well, why don't they put these slumlords in jail? A LLC is not a person, so they must be represented by an attorney. Corporations are not recognized as individuals. That's why there's never jail time to put in. But the city of Cleveland, in their ordinance, have a right to go after the principal owner or principal agent, LLC owner. Sometimes they do. A lot of times they don't. They just go after the LLC. And with that being said, we get a lot of them in because of the high fines that they look at. I even question sometimes the plea agreements. The city determines how many days to go after them. It's an ongoing offense, right? So 10 years, some of these violation notices are from 2018 and they've never been abated. They only charge them with 30 days, and then they plea them down to like 5 or 10.
Mm-hmm.
So a lot of that is, or they request to plead them down to 5 or 10. And I don't know what kind of balancing the code enforcement prosecutors do, but from the bench, if you're going to plead out, it has to be significant movement going on. Like, they got the renter registration, they've registered the property, they got, all of these other things that they know that I consistently order. It has to be some good faith movement on that in order for me to say, yeah, that's a good plea agreement. If not, I just push it back and say I'm not going to accept that plea, and they have to go back in.
So tell me, as a quick follow up to that, and then I promise we'll move on to another question.
Mm-hmm.
Like you said, I think a lot of average Clevelanders have this feeling and understanding that it's not correct. It's not just for these landlords and these slumlords to get to, really ruin or impede someone's life with faulty utilities, with unabated leaking roof, like you said, or refrigerator, or oven, or whatever. And like you said, you can't smack down your gavel and say jail for everyone.
Mm-hmm.
So tell us more about the prosecution process. Is this the municipal prosecutor's office? Is this a special division? Who can people talk to?
And so we're out telling the community in our resource clinics, and especially when we have these 101s, and I've created Tea Talk with the judge, because I think a lot of people really don't know how this process looks. And, housing court gets blamed for anything housing. And it's honestly never us. We start off telling them the judge can't go down and create cases. We're prohibited from creating cases and bringing them before the court, because I'm always supposed to be impartial, unknowing about what's going on until the prosecutors bring it. So I tend not to follow news stories about housing around. I tend not to have these one-on-one conversations where they're talking about, I'm before your court. How do I deal with this? I kind of refer them to my housing specialists who are not attorneys, but they can give them guidance. We firmly believe that people shouldn't get passed around when they really want to know, because it only frustrates them. And I feel like this is a learning court. This is a community-based court. And so I pride myself in really trying to educate people to what they should do to be stronger advocates. A lot of people call their city council member. And, without keeping in mind the city council is responsible for, I believe, 25,000 constituents. And they're the legislative arm. So they're not necessarily going to remember that Miss Johnson has a problematic property next door to her. It's not going to be a priority because they have so many other things on their list. And so I kind of encourage them to get an idea of what they need to do. Call us. We rather for you to know what to do next than not to. So what my housing specialists do is, if it's a problematic property, they'll research to see if there's been any violation notices on the property. A lot of times they'll say, yeah, an inspector came out, but we haven't heard anything since. And so they will get the violation notice and they can email a copy over to them, or they can pick up a copy of that violation notice, because the ACELA, which is the Department of Building and Housing system, is not user friendly for the average person. And even though it's public records, it's not user friendly, and everybody knows it, right? So they'll pull that out, and then they'll tell them that you can either email the inspector and encourage him to go talk to the code enforcement prosecutor, or you can contact the code enforcement prosecutors to say, hey, a violation notice was put on this property. Is there anything you guys can do? Because it's been like this for so many years. And there's a lot of violation notices out on a lot of properties that have not been properly closed out. A lot of landlords don't know that they should get it closed. I'm noticing landlords don't know what to do when they make the repairs, and so we kind of train or teach them that, violation notice, in order you can make the repairs, but if the inspector who issued you this violation notice doesn't know that the repairs are done, it doesn't exist.
Right.
And so that inspector is required to come out, because that's that inspector's violation notice, and they're the only ones that can close it out. And so we have kind of taught them how to go about contacting it. You have trouble contacting the violation notice. A lot of people want to call. I'm like, if an inspector picks up this phone at the desk and he is not doing his job, he or she is not doing their job, because they should be in the field. So the best form of communication is always email. And it's also a timestamp receipt of you sending contact to them. So those little nuances, a lot of people don't stop and think about that's what they should do. And so we have a landlord training coming up, as a matter of fact, our last one for the year, and it's October 11th at the food bank from 9 to 12:30, 9 a.m. to 12:30. There is a registration requirement, but we do have landlords coming from California, New York, PA, all over. Our last training back in June, I believe, I think we had 60 people show up.
Wow.
53 landlords, property managers, and attorneys
That's great.
that showed up. So it's a pretty good turnout, and they get a wealth of information. We try to streamline it a little bit and make it a little bit more impactful and knowledgeable, but all the way down to talking to your tenants, establishing a relationship with your tenants. And if that's uncomfortable, making sure you get a good property manager. Our property managers are not created equally. And so some of them will abscond, to even teaching them how to get a certified bonded contractor, and making sure that they pull permits when they are making repairs, and that you see the permit, to making sure if you hire a landscape to cut your grass and remove junk and debris, that you make them. This is simple things that I think everybody should know, but I'm finding out a lot of people don't. Is when they contact you to say, hey, we just cut your property, the grass of your property, make them send you pictures or FaceTime you, so that, and walk around the properties. They would only send the front, and the back is in disarray. But we won't know until they come back before the bench for a status update on their probation. and the back is overgrowth, trees, junk, and trash is back there. And they said, wow, I thought my property manager and landscaper was taking care of that, but how? And it didn't dawn on them to ask for photos of the properties of the job that they paid them for to do. So it's kind of teaching them that you really can't be a landlord just from your couch. You really have to be hands on. And I also stress that if you're not going to be hands on, the property manager will know that, and the property manager will not act in good faith. That's the best I can say it. You're going to be one of thousands who say, I sent money, I sent $10,000 to make the repairs, and they never did it. We teach them to forecast actually visiting your property, to people buying property from infomercials and not knowing the property is condemned. And so we also teach them to, if you're going to bring it out of condemnation, this is what you need to do. And we also link them with all the required inspectors to bring it out of condemnation. So we have several properties that have been bought out of condemnation and not demolished. I always think of that as a win because it brings in more affordable housing into the community.
Right. The Court of Appeals above you has voiced concerns about the use of community control in cases involving corporations or limited liability companies, LLCs.
Mm-hmm.
First, could you explain the critique in non-legal language? And I have the quote here.
Mm-hmm.
And second, what do you say in response?
Okay. And so the quote is significant concerns with the pattern employed in the housing court, including its use and implementation of overly punitive conditions of community control. So let me just say that when I took the bench, the prior cases from my predecessors had worked its way over through 8th District dealing with criminal cases. These are criminal cases. And, I think it has shaped into the 8th District ruling saying that housing courts should not be punitive in their community control, but should be helpful. And listen, I'm a read the law kind of girl. And the law is the purpose of community control is to do specific things. It is to prevent recidivism. It is to encourage compliance, and it is also to punish, right? It says it in the Ohio Revised Code, which is what governs everything. And so when I fashion it, I start off saying that I try not to cause financial distress. I write out what you're ordered to do and what you're ordered not to do. And I expect compliance, right? Because I give you the first time I sentence 90 days to start moving towards compliance. And it's always a list. It's always written out so anybody can go and check for what the judgment entry and order is. And let's talk about the first case. Southwest Investment LLC was where I had issued an oral order not to give, sell, or transfer the properties. The maximum fine they could face was $50,000. I stayed the $50,000 fine as long as you follow the orders of the court. That's written, is said repeatedly. And so, when I do the prohibition, the oral prohibition not to give, sell, or transfer property, everybody leaves out that part without the court's permission. And the reason why we want you to go through the housing court specialist to report back to the court is because we don't want this property sold to an investor that is not going to take care of the violation notices, that will get in the habit of flipping the property. And you're flipping it to an LLC that's not registered with the Secretary of State, that have cases pending on the court's docket, that has a history with the court outside of filing evictions. So we make sure that they're a good investor and their intents are known if that's what's going on. So this particular case, the LLC sold a property. And it was towards the end where they were taking care of everything, and they were trying to hide the fact that they sold a property. It just so happens my housing specialist bumped into the attorney that looked like he was shocked when they bumped into each other. That prompted the housing court specialist to go and look at just the property of this particular case, and he noticed that they sold it. They had transferred it. So he filed a notice of community control violation requesting a hearing and listed that as a violation because it is. And so we went on record, and I'm a record keeper. I like to articulate what we're here for, and that's the reason why they favored us. The 8th district can, you're going to have judges that don't agree, but they're going to be the one that didn't rule in favorable to the court. So they went across the street. I'm gonna tell you, any case filed with the Court of Appeals makes me nervous because of the code enforcement prosecutors. Um, they're not strong. Argue. They don't go over there on behalf of the court's rulings and behalf of the court's logic. Because if it was a problem with me issuing orders, they should articulate something. But they weren't happy that I ordered that 25,000 of the $50,000 payment be made, and that was coming from the proceeds of the sale because you violated the order and you went against it. And my concern is always this: how do you get people to follow the orders of the court to get them off the docket and not come back before the court? Because a lot of times they will continue to get new cases. They'll get citations and tickets, civil tickets included now, if they're not doing good faith to get off the court's docket. So Southwest, they were ordered to pay $25,000 of the $50,000 fine. They filed an appeal, which they have every right to file anything in the 8th District Court of Appeals. They ruled that I was valid in that. But then, in the same breath, not knowing the community wants these landlords held responsible, but they in their rulings states that there's concern about how I deal with involving cases involving corporations or limited liability companies. And so anybody that is looking to sit in this seat has to be fair and impartial. And you reading the ruling should not be part of your reasoning to be on this case because they violated an order that if you so happen to get this seat from me, that you're going to have to deal with these same LLCs, these same defense attorneys, these same problems, and you're going to have to work the bench from a firm place and space. It's mutual respect. And so they paid that. And then when we talk about Sopchak and Harvey, these are individuals. And Sopchak dealt with another property, but the court has jurisdiction over all the properties. And it is a residential property. There is concern with the residential property that there may be hoarding. The property is badly dilapidated. There wasn't any violation notices on it. The city believes that they should, believe they'll tell you under Mayor Jackson administration that there wasn't a lot of case filings for individuals. They believe that there shouldn't be a penalty for people that could possibly be financially challenged. Well, we have a selective intervention program for that. And a lot of times it is not, they may have the address on their driver's license, but it's rental property. And so it has to be a balance coming from that office and then how they present before me, where, Harvey may look like, because it's represented by public defenders, which is also a rising problem, that the public defenders, I have had conversations with them. When I initially took the bench, they wasn't representing landlords. They only represented, and these are the older public defenders, they were only representing individuals that lived in the property. Now they're taking on cases of individuals that own multiple properties. And not only do they own a few properties in Cleveland, they own properties throughout Cuyahoga County. And so I just informed them they may want to rethink their intake process for this court, because rarely I don't send anybody over there and suggest they take them like some of the other courts do. I tell them if they can't afford a attorney, the public defender office is there, but more than likely, it's on record, more than likely they will not represent you because of your landlord. You don't live in this property and you're collecting rent. They came back and said they determined financially whether or not they'll accept someone. I'm not going to get in a pissing match with them, but I'm mindful when they file things in the Court of Appeals that sometimes it can look like the person lives in this property and they don't. So it's a lot of things going on, but at the same time, um, when you're dealing with local rules, and I'm just going to say this out front, 8th District has no authority over a court's local rules. The only person that has authority is the Ohio Supreme Court. And so when you challenge the local rules, and that includes me issuing my community control, it should be dismissed because the Supreme Court is the only ones that could tell a judge how to fasten their local rules and their community control.
Yes, and I think this is an important point for viewers, which is why don't the appellate courts have jurisdiction over local rules like yours?
Mhm.
Because I think the impression is, oh, it's the next court above you, it's where you appeal the case. Why wouldn't they be able to review that?
Well, it depends on what they're reviewing.
Mhm.
So when there's a challenge of me ruling on my community control, which are listed and gives me jurisdiction over all properties in the city of Cleveland, I believe that because it is dealing with the local rules and my, community control orders, that my boss, because the only people that can tell a judge what to do is the judge's bosses, which is the Ohio Supreme Court. And they can look over and say, yeah, you need to change this local rule based on this reasoning. And then it cites case law, and then it governs all of the courts moving forward. 8th District is jurisdictional, and it's a court higher than them. And so as they issue these orders, and here's the number one problem is there's only been four other judges that ever sat on Cleveland Housing Court. Before Cleveland Housing Court got established in 1980, it was part of the rotation of the Housing Court. And so a lot of the judges that sit on the 8th District Court of Appeals came out of Cleveland Municipal Court, or came out of the Court of Common Pleas, or came out of private practice. And no one has ever dealt with housing, period, not even for an eviction. If they were in Garfield Heights and they were a judge in Garfield Heights, they would have dealt with housing. At Shaker Courts, they would have dealt with housing. But when the majority of them comes out of Cleveland Muni Court and Cleveland Cuyahoga County Court of Common Pleas, they would never have touched a housing case. They don't really review all of the rules and regulation governing housing court, because Cleveland and Toledo really have their own, and in Franklin County, who has an environmental court. These are 3 specialized jurisdictional courts in the state of Ohio, which is rare, because there's only a handful of states and a handful of housing courts, period, throughout the United States. So it is really trying to shape how I rule and how I issue my control orders, with taking everything that I know about this particular defendant, these background issues that may not make it in the transcripts or anything across the street, because we don't send those reports over from the housing specialist when we do these status hearings. And so they have to be able to have, the code enforcement prosecutor should be a lot stronger in advocating why the court moved the way the court moved.
And you've said a couple times across the street, and
Mhm.
I know to what you're referring, but could you
I'm
explain?
sorry. So across the street is the 8th District Court of Appeals. It's directly across the street, adjacent from the Justice Center.
Absolutely.
So when we say take it across the street, that's our short way of saying take it to the 8th District Court of Appeals. And I'm mindful of that. I feel like due process is always important, and it's something that I don't take, that I take serious, and I encourage people. You have a right to appeal me if you think I'm not doing this right, or you think something's going on. You have absolutely a right to appeal this. I don't think the code enforcement prosecutors like appeals, but since I've been on the bench, heavy uptick in appeals. That's not, you can say it's by design. There's a heavy uptick in bench trials and jury trials that I feel like the code enforcement prosecutors have never been prepared for.
Mm.
My understanding is my predecessors never had jury trials. I've had about 5 or 6. And they didn't have that many bench trials if they had bench trials. I don't force any kind of plea agreements in negotiation. Everybody, if they want a jury trial, they have a right to a jury trial. I'm there 5 days a week. That is my job as a judge, and I don't have any problems with that. Um, you know, the code enforcement and sometimes the defense attorneys feel like, well, we don't want to waste resources, and it's what the defendant wants. It's their constitutional right to either have a bench trial or a jury trial, and I honor that. So I don't yield and try to, you know, get it not to happen. But there's times where there'll be a offer to dismiss the case because they don't want to go to jury trial. And that is the code enforcement prosecutors. And I don't have a problem saying that. They're not as strong as they should be. And I feel like the community should know it.
So you've brought up the code enforcement prosecutors a number of times.
Mm-hmm.
And I think that a lot of people envision maybe an inspector who goes out to a house
Mm-hmm.
and sees a violation, they file, that violation somewhere,
Mm-hmm.
and the person has to pay it. I don't think a lot of people understand the real mechanics.
Mm-hmm.
So could you first tell us, is the code enforcement prosecutor, is that a prosecutor's office? Is that with the county city prosecutors?
Okay, so the code enforcement prosecutors are separate from the general prosecutors in the city of Cleveland. The general prosecutors deal with Cleveland Municipal Court General Division with the other 12 judges, and those cases deal with DUI, assault, domestic violence, disorderly conduct, traffic tickets. The housing court has its own type of law enforcement. And so when I explained this out in the community, I said if someone broke into your car and stole all of your items, your valuables, who do you call? And everybody say, I would call Cleveland Police Department. Okay, and then said, so when you're living next to a dilapidated house with a whole bunch of vermin running around, rodents, groundhogs, the grass is extremely high, it's overgrowth, it's dumping, who do you call? And a lot of people will say we call housing court or we call our city council person. And I said, yes, but that's not who housing court's law enforcement arm is. And it's not from us, but Cleveland Police Department works heavily with the general division. Ours is the inspectors from the Department of Building and Housing, the inspectors from the Department of Health. They're two separate departments. And then also Cleveland police officers do have limited jurisdiction to write minor misdemeanor tickets. Those are the people you would call. You would call them, and then the police department goes over to the general division prosecutors or the general prosecutors, and they get those misdemeanors in the 4th degree and all the way up to misdemeanors in the 1st degree filed through that office. They also do the bind overs if it is something more serious that they would have to bind it over to the felony court and the felony prosecutors. And I used to be a City of Cleveland prosecutor also, so I know the process of that. The code enforcement prosecutors work in City Hall. They don't work in Justice Center. They're also dual titled. So they're assistant law directors And those are administrative attorneys that deal with creating law, but then also being over, like they would actually be my assigned attorneys if something happens to me, to any of the other departments, including the mayor. But they have ones that are also marked as code enforcement prosecutors. And it's kind of complicated because I know how a prosecutor office should work as a former Cuyahoga County prosecutor and a former City of Cleveland prosecutor. We do intakes. We have designated days to listen to the officers and detectives come before us, and then we make a determination what charges should be issued, how many counts should be issued, and then we sign off on the complaint so that they can file it with the clerk of courts, Cleveland Municipal clerk of courts. Once that's filed, it's given a case number. So a lot of times, I know also as a former prosecutor for misdemeanors and felonies that it's hard to switch hats and become a civil attorney. And so that role, if you're doing dual roles like that, it is going to become confusing. Even if you look at the city of Shaker, they have assistant law director, but they have a designated prosecutor. City of Warrensville have assistant law directors and directors of laws, but then they have a separate prosecutor. There's a reason for that, because you will start to confuse the roles and conflate the roles, in that you will say things like, we have a settlement agreement, instead on a criminal docket, instead of saying we have a plea agreement. And then there's a belief that you can dismiss a case at any point whenever you file it. And you can on a civil docket, you cannot on a criminal docket. You have to use the rules of criminal procedure. You can't get it conflated with the rules of civil procedure. And so there is some necessary training that is needed for the city prosecutor's office, in that they are clear and can clarify their roles and not get it confused with assistant law director and prosecutors, code enforcement prosecutors.
In the last budgetary conversations between the housing court and city council, correct me if I'm wrong, but there was a surplus, was there not?
A surplus
Of funds. You didn't. The court didn't use all the funds assigned to it.
right.
Would you be able to? Is it within your authority to hire someone who would serve specifically as a housing court prosecutor, or is that not within your purview?
No, that is so code. The prosecutors are up under the executive branch, and I'm glad you asked that question, because a lot of people think the prosecutors work for us. They do not. Nobody should work for the court except for court staff that's involved in moving the cases forward. But no, we're separate and apart from the executive branch. They have, I think they've hired about 7 code enforcement, so it's not a lack of manpower.
Okay.
It is, from my view, training of them, because they do dual roles. They do other things besides just prosecute. Whereas the general prosecutors, that is their role, is to prosecute. And it becomes, it looks, and it will come out confusing a lot of times on record.
For the voters, could you tell us some things that you disagree with your opponent on, and why?
Some things I disagree is that you don't have a platform, and the things are about getting the union back in there. Like, that's something you would never hear the mayor say. I'm going to make sure the union is there, because you're not part of that process. You're not part of the process, and then you don't understand the process and what it looks like. When I took the bench, and very quickly, I had 3 of my 8 bailiffs tell me they didn't want to pay union dues anymore, and I didn't really know we had. I didn't know we had a union. First, to be clear. And so in that, I was looking for the union agreement, the CB collective bargaining agreement. None of the bailiffs had a copy, which was disturbing to me, because you should have a copy of something you're paying a membership due to. and only one who is probably still advocating for a union. Um, you know, he didn't even have a union agreement. So my chiefs and deputy chiefs, they didn't have, because they could never be involved in the union. And I called the law department because we have to do a thing called judicial judge school. When we win, we have to go down there, and so they talked about being an administrative judge, which I am. An administrative judge is over a budget, over their staff. um, Cleveland Municipal Court has two administrative judges. So Judge Early is the administrative judge for general division. I'm the administrative judge for housing, and we go before City Council for our budget. Judge Early is also the presiding judge, which is the judge over the entire Cleveland Municipal Court. And that Cleveland Housing Court is not a separate court on until its own. It is just a division within Cleveland Municipal Court. I'm having to kind of reinvent how that looks because, I think there has always been a move to separate the courts, and they should never have happened. I'm a team player. The Ohio Revised Code says that this is part of the court, and I don't know how people stray away from that, but I'm to rectify the whole thing. So the collective bargaining agreement, we were told at this training that it's 529 courts in the state of Ohio, and only one court has a collective bargaining agreement, and it's in southern rural Ohio. I can't think of the name of the court. They had stated that they believe it was two, but they didn't know who the court was or where the court was. And so I didn't think anything of it because the Ohio Revised Code tells you what should have a collective bargaining agreement and who's prohibited, and then who can do it if they so choose. We fall in the middle group, course. If we so choose, by we mean the judges, to allow that to happen, then it can happen. But the prosecutor's office prohibited. State attorney general's office prohibited. And so it's certain things in Ohio Revised Code that says what can happen. The purpose of a collective bargaining agreement is an employee's handbook. Our employee handbook is 125, 130 pages long, very detailed, and the court always adheres to labor laws, to the Ohio Rules of Superintendent that governs courts, to also the Ohio Revised Code. And so everything for every department is covered, including pay. But to be clear, when I took over this court, there was some serious pay inequity, and some people were making extremely high incomes, and it was only a few, and a lot of people were being underpaid. One of the things that I noticed is that a lot of my staff was running out to work part-time jobs, and we lost two of my bailiffs at one time because they went into positions with, I believe it was Brecksville's police department and RTA police department. To lose two bailiffs it has an impact on the court, being that it's a very small department. And I asked them why, and they was just like, we can't afford to keep working here because we would have to do a lot of overtime. And our overtime only gives them comp time, but they work part-time as security. Um, so it prompted me to want to go look at what we were paying them. The average pay in the bailiff's department, let's say, for example, was 45,000 was the starting pay. And that was due to me ticking it up a little bit during the pandemic, even though we weren't supposed to ones that had been there 8 years, 10 years, was only making about 48,000, no more than 52. So I did a pay increase across the board for everybody. We had to do emergency legislation because I felt like this court is very voluminous, and we have dockets and we're on record 5 days a week. We have high volume people coming in just to ask questions. So I bumped the starting pay for the bailiff's department to 60,000 a year. My housing court specialist starting pay is 60,500, and my magistrates who really work overtime, their starting pay got bumped up to 95. And that was done because I feel like you always have to pay people their worth. And we do everything. We give the paid holidays, we give the housing, um, the uniform budget. We give them that. So it's funny because I finally got a copy of the collective bargaining agreement from the CPPA, from Cleveland Police Patrolman Association, I think is what it stands for. um, a while, a fully executed copy. I had a draft that was saved on a hard drive, but nowhere in my files with the court or with my court administrator could we find an executed copy. And I thought that was odd. And so we finally got a copy. We reviewed it. It was 12 pages. And 12 pages, it is always set to expire December 31st at 11:59 p.m. It's automatically expired, and it must be renewed at January and executed by the sitting judge, right? So it was in fact already, they didn't have a collective bargaining agreement, although CPPA was still taking money out of their checks to pay for the union dues. And when I went through and read the pages, and I might be nice when I say 12, it could be like 10 pages. A collective bargaining agreement usually is 150 pages plus, because that is the employee manual for those union members. It governs everything from the time they work to the time they get off, to comp time, to uniform allowances, to all of those. Those are all covered in our handbook. So the only thing we found out that they were negotiating with was to have an attorney present in a time where there may have been deadly force used in an eviction. That's when it was enacted. I believe it was 2012, I believe, is when the first union agreement happened. And that was really the only reason that they have an attorney on retainer, because the union members, they have that in their union contract. Anything else in that collective bargaining agreement said that this collective bargaining agreement shall not supersede the employee manual of Cleveland Municipal Court Housing Division, or no, not or, and the judge's discretion. Meaning that I could easily, or any of the judges could easily say, no, we're not here to discuss that, because they can't collectively bargain for increase in pay, step in pay, or anything like that, because none of the other court employees can do it. And so when they say the starting pay is this, the starting pay is that, because that's how it's budgeted. And so they can't be, oh, well, you get paid this much, because then it would call into question the heavy pay disparity that I saw when I took over the court. And so some of the other things about high turnover. Um, every job has high turnover, and it's not because we're firing people. People have a right to leave. We do not own a plantation in Cleveland Housing Court. When I took over the bench, I had a right to bring in my own team, and I so choose. That meant that 8 people were let go, and those were the chiefs and deputy chiefs. Court administrator was already gone. They didn't have a deputy court administrator, HR person. They didn't have a dedicated HR. They didn't have a dedicated finance officer. They didn't have a lot of stuff that I implement, I legislate and put on there. And regardless, when you talk about people coming on in the court, there is a 6 months probationary period. Some people thrive, most people thrive, some people don't. I inherit also an old court, not by age, but by people that have been there 20 plus years. They were there when Corrigan was on the bench, then Pianca, then O'Leary, and then me. And so the pandemic is another thing that a lot of people forget that we lived through. Um, People in the court, in my court, lost spouses. They lost kids, they lost parents. That is an impact on people's mental health. And so we had people resign, people having to deal with immune deficiencies and still being out in the public, and really needing to be home, to having long haul COVID. And then, we have good staff members. So our staff members get poached. My chiefs have gotten poached, and poached by their dream jobs. So as we came out of the pandemic and more people started looking for better employees, Some of mine became vulnerable, and I poached. I poached heavily from some places that I know that dealt with high volume. So it's a lot going on, but we're talking honestly. You're trying to say something about housing court that's not true. The perception is not true. I didn't get rid of the collective bargain agreement. I was asked by staff who didn't want to have it, by the bailiffs, that it is over. And so when I reviewed it, and it was right before the pandemic, I decided not to sign on behalf of them. They weren't even in agreement to all have the collective bargaining. And you got to have some kind of agreement amongst all of them to be back on it. So I don't have to tell the CPPA the reason why we didn't move forward. It was really because they didn't want to. Not all of them, and all of them had to back then. Now, I know another case has come down that says, they don't have to join the union if they don't want to through the United States Supreme Court. But to be on the up and up, we took time, my court administrator took time explaining the collective bargain agreement with all of them, because if they so desire to go back into a collective, me as a judge of Cleveland Housing Court has absolutely no problem doing that. So we set up a meeting with them to talk about the purpose of a collective bargaining agreement, to give them a copy of the old collective bargaining agreement, and to see, just review it and see what it says, that and that you're aware. A majority of our bailiffs are new. They spoke to my court administrator. My understanding from that conversation and answering questions is that the majority of them are not interested. And so for an opponent to be out here saying she's going to bring the union back as a speaking point, it's not going to work favorable if she was to win this seat. Because that's not what the staff do, unless she plans on doing what she's alleging I did and firing everybody. Because that's what you have to do to reset. A lot of the things that I've put in place is to fire or ask to resign. And so with her speaking about, high turnover in housing court and misrepresenting the amount of people that I let go when I first took over the bench. She did some number 12 and it was 8. And there was just the administrator. It was not any of the other staff. Is false. And that I would be interested that if by some miracle she was to win this seat, is she saying she's going to keep all of my staff and not have high turnover as she's alleging that's going on with me? That's very problematic. But it's a lot of people that are those administrators that want back in housing court. That it's simply not going to happen. Move on with your life. I am going to get 6 more years on this bench because I have done right by the voters, and that's all that matters to me.
In a Signal article from August of 2022, you voiced skepticism that Mayor Bibb's Residents First law, requiring in-state registered agents, would do anything to curtail delinquent out-of-state landlords. Now, we've just passed the year mark of that law being in place. Have you seen it work or not work to do its intended purpose?
So that law was that part was requiring LLCs to have a local agent in charge. And the local agent in charge, according to Residents First law, is responsible for making the repairs of the property, closing out the violation, paying for the repairs of the property, and making sure that the property is upkept and that they are everything responsible for anything that has to do with this property. And so what's confusing is the city keeps using local agent in charge versus statutory agent versus principal agent. And local agent in charge, what I see is a lot of LLCs can't find one because the way the law is written is that that local agent in charge is responsible and can be held criminally liable for not doing anything that the city has deemed should be done, like closing out a violation notice. But the local agent in charge is not the actual property owner. These are for people that are outside of Cuyahoga County, outside of the state of Ohio. They may not be touching Cuyahoga County or city of Cleveland. We have some people that live in Cincinnati that own property. And so the local agent in charge is tantamount to a property manager, and property managers cannot be held criminally responsible for not making repairs. No one can, because you can't. I couldn't go and pay your property taxes because it's not permissible and it's not lawful. And if I did do it, then I would start staking having ownership in your property because I paid your taxes. Unbeknownst to you, I made the repairs. That, and then I can argue unjust enrichment, right? Because I made the repairs, I should own this property. It's unjust. And then I can't afford as a local agent in charge because I'm over several properties that do not belong to me, but I'm responsible for managing them. If I am responsible criminally because I didn't make the repairs that was given to me by the inspector, then how am I liable for something I don't own? And property managers change like the weather. I don't know too many people that is on my docket that keeps the same property managers. You have to figure out where it works for you, what one is willing to do versus the other. And so they cannot get their certificate of proven rental occupancy, which is the Cairo, that the city was wanting the court to use in order for them to access the eviction process until they get a local agent in charge. And I say that Cairo is fluid because they add stuff that I didn't even know they added. And so I want to clarify too for those that's out there that in order to file an eviction, you just need your renter registration receipt because they no longer get the renter registration certificates. But all you have to do is show that you have registered your property with the renter registration unit. You do not have to get the Cairo to file your complaint for an eviction. The way it's written on their website is very confusing because it was saying in order to get your rental certificate, you need this Cairo and you need to do all of these things. And I've just noticed an uptick in defendants not having like a rental registration or having the property registered, and it's because they're misinterpreting what the website says. And it's very easy because it looks just like what it says. And we've asked the Department of Building and Housing to kind of separate that, but I feel like it's always going to fall on housing court's duties to educate people. But the local agent in charge, it makes no sense, and the defense attorneys are just like, their clients are being required to have this, and some get them, but a lot of them are not because they don't want the liability. The property managers don't want to take that on. They'll manage your property, but they won't sign on as a local agent in charge. I was told that that's being challenged in federal court, so I'm not sure how true that is, but I just wait for the outcome and the shift.
Almost 10% of Cleveland is owned by the land bank.
Mhm.
With poverty at all ages rising in Cleveland, especially since COVID, would you support building good, affordable public housing on land bank parcels?
I mean, I don't, as a judge of Cleveland Housing Court, I don't really have a say. I support building affordable housing anywhere. I support that Habitat for Humanity is out building affordable housing and teaching people about home ownership. Um, Anytime, I support property owners that have condemned property with getting the property out of condemnation and making it affordable, which is why I don't activate any fines when a lot of times it could be up to $150,000 fine I could enforce. I don't charge any fines. They are just responsible for court costs and fees. And so, yes, I support affordable housing. I'm not sure how many parcel or percentage the Cuyahoga County Land Bank owns because the city of Cleveland also owns a lot of the vacant parcels. The land bank tend to own parcels with homes on it. The city land bank of Cleveland owns the vacant lots. So anytime there's developers that want to build affordable housing, and I think it needs to be very clear about what affordable housing looks like, because I've seen that these things can go out of where you have to reserve 20% or 10% of the units for people with for affordable with income that qualifies, that they're not paying the fair market rate, because as we discussed earlier, there's really no such thing as a fair market rate. It's a free for all unless the state comes in and do something about stabilizing rents. And I'm just going to go back because I track data and I read up on things. There is a 10%. So the city of Cleveland, they named 10 cities where there has been a rapid, they're the fastest growing in rent and how much rent costs is up. That's Cleveland is number 2 and Toledo is number 7. That's from Smart Assets, which is part of Zillow. And the average rate of rent increase is for the state of Ohio is 2.5. From 24 and 2025, May of 2025, the combined increase in rent has been increased by 7.56%, I think.
Wow.
So it's a really high rate where you used to could get a single, one unit or a house, a standalone house for about 850. Your average pay is now 1,300 for the family, and we know that rent rate continues to increase, but employee wages are stagnant, if they're existent, and that there is about to be a lot of defaults. So we possibly could see more foreclosures, mortgage foreclosures, which is not tax foreclosure. I have seen on the bench that a lot of these mortgage balloon payments have started to affect a lot of investors, and that they have just property sitting out here that they're losing to foreclosure and receiverships. So it is going to all run into each other, and it is going the very limited affordable housing we already have in Cleveland is going to become worse, and there may be a high increase in unhoused individuals.
Housing court handles evictions, as
Mhm.
we said many times.
Mhm.
For average people, an eviction is a traumatic and difficult process, which is usually related to the loss of a job, the extreme change in income, or other life altering events.
Mhm.
What will you do, if reelected, to mitigate the effects of evictions and hopefully to avoid evictions in general?
Um, so there is no avoidance of evictions. What we do is limited. Um, what was very good that was going on in 2020, 2021, 2022, and 2023 until there was no more was rental assistance. Everyone saw a serious decrease in evictions. And we haven't got back up to the pre-pandemic numbers because they were averaging physical move outs in the thousands, like 7 to 10,000 a year. It was high. The volume in housing court was high. The pandemic hit. Um, if we this year may be our first time that we get to 1,000 physical move outs. And we encourage mediation. So we try to get to some resolution to where an eviction won't take place, like a physical move out. They mediate that, whether they agree to pay the back rent and the rent moving forward so they can stay in their apartment, to whether they will agree to move out by a set date, because sometimes the landlord, they don't care about the back rent, they just want you out of their property, and this could be the easiest way to do it by giving you a deadline. If not, then it moves forward with the actual move out eviction. So we have a tremendous increase in our mediation that we do in Cleveland Housing Court. And, just speaking on what my opponent has said with me sitting next to her, is that we only have one dedicated mediator. That's correct budgetarily. But we trained all 12 of our housing specialists to be certified mediators through the Ohio Supreme Court. And so they sit in on a lot of those mediations. We have an increase in dismissal of cases because people have agreed to dismiss the case by paying a lump sum or moving out or whatever reason that comes across for it to be dismissal. There has been a high uptick in dismissals and mediation. And we are still, I haven't seen the numbers this far this year, but last year we were right up under 1,000 move out evictions. We can have cases filed. We had about 7,000 cases filed. First, forcible entry detainers, also known as evictions, that complaints that were filed, but we only had less than 1,000. I'm trying to remember the number, set between 700 800 physical move outs. And so that's the numbers we get from our bailiffs who tracks how many properties they went out to. So it's been a decrease, and it's through a effort of right to counsel that took effect in July of 2020, working with them to make sure they have access to the tenants, and then going out in the community talking about rent escrow, talking about payment of your rent, and then bringing things to the court's attention before you get evicted, because we want people to be proactive and not reactive. And outside of coming up with money, nobody can stop an eviction for non-payment of rent. Is a majority of our evictions. It's non-payment of rent. So we try to help those we can, connecting them. Those are our seniors. Those are our veterans, where there may be some money or some rapid rehousing. But the majority, the court hand is tied, as well as the city overall. There's a lack of affordable housing. So I have conversations when I go out in the community about paying your rent. If you think your rent is affordable where you're at, imagine trying to look for new housing somewhere else where if you're paying 750, you're not going to find 750 for a 3-bedroom anywhere in Cleveland, east side or west side. That's the unfortunate part.
We looked up your voter roll, and according to the ORC, the last primary that you vote in is whatever party you belong to. So we see you belong to the Democratic Party. After the last election, the Democratic establishment decided that it wanted to pursue a more moderate conservative position in an attempt to win. Do you agree with this move?
So I'm a judge and we're nonpartisan. I believe in the Ohio Constitution and the United States Constitution. I believe in those rights that are solidified in the United States Constitution, whether it is by amendment or whether it is by case law through the United States Supreme Court. I don't take a personal stand on national things, but I have a personal belief in how I feel. I feel like everybody should have a right to choose, that everything is at will, it's your choice. And that's biblical. If we want to talk Christianity, even God gave you a right to choose. It said choose life. It didn't mandate life. It didn't put down in the 10 Commandments that you should believe in me. You should be saved. You should do these things. It said you shall. And as an attorney, shall, must, will, or should makes a difference, right? One is mandatory, one is optional. I just believe that a lot of your personal belief, in order to be a true judge, should be fair, it should be impartial, and it should be unbiased. Anything that comes before you, you have to look at everything with that specific lens to that specific defendant and that specific person and the facts laying around that. My personal beliefs should not come in. Me not liking somebody should not come in because it's not fair to the person that comes before you as you sit on a bench. So, what I believe in is the United States Constitution and the Ohio Constitution. That's what I took an oath to. That's what I stand by. And one thing that I do stand by is due process.
Absolutely.
Period.
Well, and as a follow-up, like you said, this is a nonpartisan local race,
Mm-hmm.
but judges at all levels and
Mm-hmm.
all corners of the legal system have been instrumental in slowing fascism from taking over with the MAGA movement.
Yes.
If elected, what will you do to keep our small corner of the United States democratic and just?
Um, so I'm limited, and I can't really speak on the future of what I can do, except follow my oath. When there is a challenge to deny someone due process, that bothers me. Because due process includes being put on notice of what's going on and what you're being accused of, or what you failed to pay, or what you failed to do, to having the right to be heard and not anything implemented on you. This country has moved into a you're guilty until proven innocent, when the laws have always said you're innocent until proven guilty, and that burden falls on the person that's making the accusations, right? That they have to prove it, because we are moving to believe in what people say, and put that and these people will push false narratives and create false perceptions of what's going on, without really taking it upon themselves to find out the truth. And then being challenged with AI. So it is very imperative that people do their own investigation outside of superficial sound bites, to really coming out and hearing people, elected officials or otherwise, what they plan to do, what their platform is. You should be bothered if there is no articulable platform. You should be bothered when they are only speaking points negative about what the other candidate is doing, because that's not what voters want to hear. Voters want to know, what can you do for me if I come before your court? And I'm just being real.
Yeah.
So um, I would just say I don't yield to pressure. Sometimes the hardest thing is to do the right thing, and do the right thing when no one's looking. So that's what I live by. Those are my, ethical and foundational beliefs. And that I always put myself in the shoes of what would I want to see done if I stood before me. And so I'm always empathetic in that way. And I'm mindful and respectful. And I understand that, yeah, people don't want to be evicted. People are embarrassed about being evicted, and people will respond because of depression. It's a lot of people that suffer from depression, but it doesn't look like you're sleeping all the time and in your bed. It's high functional people that are manic depressant. So we know that you may not be on top of your calendar. You may not be on top of what the court has ordered you to do. And I understand that when I'm dealing with defendants, individuals on my criminal docket. And so the court is very patient, and I extend that patience until it starts to feel like you're being taken advantage. So, I mean, that's just my belief. I don't yield to one party or the other. I just know what my core beliefs are. They tend to be democratic, they tend to be liberal, and they tend to be incompetent of everybody, putting everybody into perspective about, unaffordable housing, to unhealthy housing, to being a capitalistic society where money is over everything else. And that's really what we're seeing. And that's really what we have to speak on.
All right. So, when you were elected in 2019, you said you hope to create satellite courts
Mm-hmm.
and add a night docket to Cleveland Housing Court to make it easier for people to attend sessions.
Mm-hmm.
But as far as we're aware, that hasn't happened yet.
Mm-hmm.
Why?
We do have satellite courts. We have the virtual kiosk in the 4 library branches. We're actually beginning to start looking at other options, because unfortunately, Cleveland Public Library opens at 10 a.m. But we have had a lot of people use them in the community. So some of our options are to put them in the Cleveland recreation centers. We just ask that you have a dedicated room and space for privacy, because a lot of our virtual hearings come from uh, the eviction docket. We found it unnecessary to have a night docket, because we initially in 2020 had, within 2 months of me on the docket, they were talking about building a new justice center. And so I want a dedicated space for Cleveland Housing Court. And we talked about security so that I could have night court or evening court for those people that don't have PTO or can't get off during the court hours. We found out that when we had to go virtually, first that was going to be a task beyond our control. Just even moving evictions from the 9 o'clock docket to the later time docket, due to the clerks having to, they told me they need about 4 to 6 months just to change the time because they're that far in advance. What the virtual docket has allowed us to do is to allow people to come on during their lunch break, while they're walking their kids to school, while they're sitting in the doctor's office. I mean, unfortunately, we've had people come on that are receiving chemo. And we have had an increase in LLCs appearing from Paris to Colombia to South America, Asian, European countries, all over the world. They appear on the docket because it's virtual, and they are fully hands on and participating. We've had them come in town because of, the landlord training. And I think this works better if you put things accessible virtually. So people saying, "Oh, well, I couldn't make my flight," or "I'm traveling," I have a zero tolerance because my hearings are virtual, and you must appear. So if you decided to buy a ticket because you knew well in advance when the next hearing was going to be, that's not a me problem. That's a you problem. If you're an LLC, I'm going to start implementing the sanctions. So I will give them more time because I'll tell them you have until 2 p.m. today. If this was a 10 a.m. hearing, you have 2 p.m. to get your client on here, because no one told them they could fly. They should be flying on a day when everybody knew that this hearing was going to take place, and the last time you was here was 90 days ago. So I usually have a conversation with my housing court specialist, and they'll say there's been a horrible lack of communication. I didn't file a violation notice, but they need to be here so we can have this conversation on record. But a lot of times, when they're doing really good and everything, and they file a request for continuance, if they're doing good and they're almost complete, we'll grant them the extension. Sometimes I tell them, like, if you need a little bit more time, just ask the court, communicate to the court, and we can grant you a little bit more time instead of having to come back in here. Because every time LLC or individual come in with a private attorney, they have to pay that attorney. So again, I go back to my principle that I don't want to cause a lot of financial distress. I'd rather for that money to go back to the property, not in the pockets of different people, and not in the pockets of the court. We don't gain anything out of it. It doesn't even come to us. It goes across the street to the overall city budget.
Thank
So
you.
you're welcome. You're welcome.